Hi, everybody. I'm Liza Hausman. I'm the Vice President of Industry Marketing here at House, and I'm very excited to welcome you here for today's webinar, Top Liabilities for the Remodeling Business in 2022. We are so lucky and fortunate to have DS Berenson here with us today to share his experience and knowledge. DS serves as the managing partner of Berenson LLP in Washington, D.C. The firm represents a majority of the top 500 remodelers. They have an exclusive national practice in remodeling and home improvement law. And he serves as general counsel and special counsel to home improvement contractors, remodeling industry manufacturers, trade associations, multinational banks, and others on a full range of industry matters. So very excited to have him here with us today. Obviously, 2022, DS is an unusual time and an unusual set of circumstances for a lot of builders and remodelers out there. So I'm going to hand it off to you to kind of start us off on the things that you think this group of builders and remodelers should have in mind for 2022.
Sure, Liza, I appreciate that. These are some strange times, but they've been generally good for the industry. Somewhat surprisingly, I don't think anyone was expecting that we would have such a large economic boom in the remodeling and home improvement industry when COVID broke. So, as you indicated, we only represent contractors in the industry and some lenders and manufacturers as well. So we're very much at ground level. So I know we have a limited amount of time. We're just going to sort of jump in and hit what are going to be the large issues from a liability standpoint in 2022. Our job is to help these guys keep the money they're making, and the money seems to be flowing fairly well right now. How long that lasts, nobody knows. You need somebody much smarter than me or any of my attorneys. But without a doubt, the number one liability that we've been seeing, and that's going to continue on into 2022, is the reclassification of independent contractor labor, independent contractor installers. Probably a good 90 to 95% of the industry, and I would expect most of our audience, are using some form of independent contractor for installation labor. And since the Obama administration, we've seen the federal government and a lot of the states take a very, very aggressive role in trying to eliminate the utilization of 1099 subcontractors, especially in contracting and home improvement. And the reason this is such a problem is because it creates a nuclear issue. You could have one person, and if you get hit by a 1-800-SUE-YOUR-LAWYER, or they go to the Attorney General, or they go to Wage and Hour, or Department of Labor, or IRS, or state wage and hour comes in, whatever happens, it can have this domino effect. And the repercussions, as we'll talk about a little later, are very, very damaging, even if it's just one or two people. So if you're going to utilize independent contractor installation labor, you have to do what we refer to as building the brick wall. There has to be an actual brick wall in your protocols. And it's difficult, especially for smaller contractors. But if you can't do it, you really need to think about putting your installers on a W-2 basis, because the repercussions are very, very damaging, well over $100,000 for each individual.
And so, isn't using subcontractors standard practice for most of the smaller firms out there, and really the majority of firms out there?
Absolutely. It's been standard practice for decades and decades. And that's one of the reasons that it's such a risk for us, because the regulations that have come in at the state level and the oversight that was implemented by the Obama administration creates this, as I said, this nuclear risk. Because what's happening is there's a belief among one of the political parties that the use of independent contractors is unfair to the workers, that it deprives them of their rights to benefits and overtime and employee rights and things like that. So we're seeing this strong push to reclassify the workers. And if you don't have this brick wall built, you're going to be at an extreme risk. So, for example, when I talk about this nuclear domino effect, just briefly, without putting anyone to sleep, if you get somebody who says, hey, you know what? I really should have been treated as a W-2 employee for the past year or the past 5 years. What the contractor's then at risk for getting hit with are state and federal payroll withholding taxes for the prior year or 5 years, workers' compensation claims, retirement benefits, overtime, attorney's fees, fines, and this adds up very, very quickly. So as I was saying before, you could have one guy and you're going to get hit with a $100,000 bill like right away.
And are you seeing this happen? Have you seen this happen? You've already seen this happen to some firms?
Oh, we've been dealing with it for a number of years, probably 3 or 4 times a month at the state and federal level. It's very aggressive. So you've got to build this brick wall. I've got a slide that we created where we can walk through the bare minimum steps. The first requirement is we absolutely have to have a written agreement in place with the installation vendor, with the guy or his company. We've got to have that written agreement in place. If you don't have a written agreement in place, you're going to lose the reclassification audit right off the bat. Number 2, you've got to hire these folks as what we call IBEs, independent business entity. I came out of the Office of Chief Counsel of the IRS. When an auditor comes in, and whether you're a big contractor or a small contractor, and they want to examine your labor structure, which is one of the first things they're going to do, anytime they see that you've hired an installer under the name Sally Jones or Bob Smith, you have a problem, because it implies right there that that person should have been treated as an employee because you hired the individual. So you must get them to set up a company or a partnership or a limited liability company and hire that entity, that independent business entity. Do not hire the individual. Very important. Make sure they get a tax identification number that's separate from their social security number. When they're looking at your Form 1099 that you file, if it has an individual's name or an individual's social security number, they're immediately going to target you. If it says Smith Coconut Construction and there's a tax identification number there for the business, they usually will put that aside and they won't even bother looking at it further. So you have to hire them as an independent business entity. You have to make sure that company has its own tax identification. Yes, they could be a sole proprietorship. They still need to get a separate tax ID apart from their social security number. Okay, very important. Now, in about 38 states, we know that contractors need to have their own licensure,
right?
Which unfortunately means that if you're using an independent contractor for your installs, they're also supposed to be licensed. Why? Well, we're suggesting that Bob Smith and Sally Jones are running their own businesses when they're installing our windows or our roofing or our decks or our siding. If they're not actually licensed under that state as a contractor, they could never actually be running their own contracting business. So unfortunately, if you want to have a bulletproof brick wall built, you have to make sure your installers are licensed if you're in a state that licenses installers. In places like California, Nevada, the law requires that anyway. Very important brick in the wall. Then you want to pay them per job. That's really not a problem. You could pay them for multiple jobs, but on the payroll, you want to mark each check as it applies to each specific job. And you want to make sure that they have the ability to work for others. Times are very good, as we talked about. So for many of us, our installers are not working for anyone else. They're working only for us.
Right.
That in and of itself is not a problem, as long as we can show that they could work for other people if they had the opportunity or they wanted to. So how do we do that? We make sure they throw up a basic web page for $10 a month with GoDaddy. We make sure they have business cards printed. We make sure we have hired them as an independent business entity and we're paying them as a business entity. And they're in the yellow pages or they've got some stationery that they invoice on.
Does it matter how many hours they're working for you? Does that affect like their, what qualifies as their ability to work for others?
It doesn't really anymore. If you've got the rest of the bricks together, you're generally going to be okay, even though they're only working for us. That's no longer as critical a factor as it used to be in the old days.
Got it. Good to know.
Then we talked about the 1099 as opposed to filing a W-2, right? So we've got to file that 1099 with the IRS, again, listing the business name, the business tax identification number. And then finally, if I had my druthers in every time our firm is defending one of these attacks, having the cover page from one of their state or federal tax returns is huge. Why? Because what happens is we're sitting across from opposing counsel who's a 1-800-SUE-YOU lawyer or who's an attorney general looking to run for governor next year, and they want to hang the evil home improvement contractor. So we're sitting there and they're saying, oh, my poor client, my poor individual here should have received retirement benefits and medical health insurance and overtime and all these things, and you're so evil and you owe all this money plus fines, interest, penalties, and legal fees. We pull out a copy of their tax return that they gave us when we onboarded them. And it will show that they were taking deductions as a business for their tools and their vehicles and whatever else. Now they've got a bit of a problem because we sit there and we say, you know what, this is interesting. Something's wrong here because either your guy should have been an employee and we've got a problem. But if that's the case, then he committed tax fraud and he lied to the federal government on these tax returns. So I can go call the district director of the IRS and we can go down that road right now. It all depends on how you want to handle this. And that's what our silver bullet is. You'd be amazed at how magically the case disappears when we talk about filing for tax fraud against these guys. So having a cover page, even if the numbers are redacted out, blackened out, having a cover page when we onboard these guys from one or two of the tax returns can be critical to saving the business.
And how can a contractor, I guess, know whether that sub has filed a tax return as a business in advance?
You've got to require it.
Got to ask.
We've been doing it for about 35 years. And I always get these questions about, well, I've only got 2 installers and this installer is the godfather to my child. And I've had Thanksgiving dinner with him. I have bad news. That's not the way it works anymore. There is no loyalty in our industry, unfortunately. And I've seen these guys multiple times. All of my attorneys have. They'll get up on a ladder. They'll break their ankle on a second-story window install, and they realize they're not doing any more window installs. So they're looking for a piece of your pie. And it doesn't matter how friendly they are when they walk into the AG's office or the 1-800-SUE-YOU lawyer's office. They're coming after you. There's no loyalty. So again, either you go with protocols, and this is just a sample of what we require. It's different in every state. But if you build that brick wall to defend your independent contractor relationship with your installers, or you better really think about converting them to employees. Because if you get hit with this, it's nuclear.
Got it.
That's
good advice. A little scary for sure.
everything.
I'm sure for a lot of companies, but good to be aware of as we roll into the new year.
Yeah.
Should we talk a little bit about contracts?
Contracts always tend to amuse us because whether we're working with Chuck in a truck and Bobby Bag of Donuts, or one of the public contractors that's doing a couple $100 million, there seems to be an epidemic failure in our industry to understand how important the contract is, and we give it short shrift. In fact, many of us, if we're going to be honest with each other, have stolen our contracts from other contractors. I was a sales rep. And I like this guy was using the contract, so I kind of just took his contract when I went out on my own. And this has created this epidemic problem where almost every contract we see in the industry, regardless of how large the player is defective. And the failure to understand the risk here is why this is the number 2 liability in the industry and has been for many years. If my contract is defective, under state or federal law, that means that every job I've written on that contract is defective. And again, you get the 1-800-SUE-YOU lawyer, you get the attorney general, and they're going to hang you for that. And your liability can be tremendous. If you're a smaller contractor, you can be put right out of business. So your entire operation is resting, yes, on the leads you get in and your ability to close them, but on the paperwork you're using to sign up that customer. And if you're not going to protect yourself, nobody else is going to do it.
And so what should contractors do? What is a good source of a good contract? And do you have to hire an attorney to do something custom?
I'm not aware of any good sources, unfortunately. There are some attorneys that can draft some really good contracts, but they need to understand our industry. Doesn't mean you need to have something drafted from new. Your contract may be in pretty good shape, but you want to be absolutely sure of it. Because remember, we talked about like the 38 states that have contractor licensure. Almost all of them have some form of regulation governing what can and what cannot go into a contract. And in every state, including the District of Columbia, there is a version of the right to cancel, which hopefully most of the audience is familiar with. So federal law tells us, for example, Lisa, that if we're conducting any sort of sale in the home, we have to provide a notice of cancellation to the customer with that sale. So that requires a disclosure on the contract right above the signature line, basically, and a separate notice of right to cancel. And that federal law requires that there are 2 copies of that notice to cancel given to every customer. So if I'm selling a husband and wife, that means they get 4 copies of the notice to cancel. If I'm selling two life partners in Massachusetts, 4 copies of the notice of cancellation. If you're only giving 1 copy or 2 copies, you're violating federal law. And every state has a version of that. And a lot of states changed around a little bit. Like New Jersey changes it around. Delaware, the disclosure in your contract has to be in a different color. In Michigan, it has to be in a larger font. All the states have their own variations on this. So if there's anyone in our audience that this is not ringing a bell with, there's a good chance their contract is completely out of compliance, which means every job, they can get hit on every job.
And what kind of liability does that open them up to? What have you seen?
We've seen everything from small fines and correcting the contract to contractors being run out of business. It runs the gamut. It depends where you are. The difficult states are certainly the People's Republic of California, Illinois, Massachusetts, New Jersey, the Northeast states, very problematic. If you're in Texas, you could literally shoot the customer if they don't, you can get away with almost anything in Texas, or Florida too, to some degree. But, there are good business states and there are admittedly bad business states. That's not a political statement. That's just a fact. In Maryland and the Dakotas, if the customer's over 65, you need an extended rescission. And all these rules change every year or two. So you need to make sure that your contract is in compliance. But as far as where to get a good contract, I really don't know. You'd have to just have a good attorney or a good law firm that understands and can review your document and get into business protections. It's not just legal compliance. It also should be written into a plain English manner, right? We don't want to scare the customer in the house. The sales rep is going to screw the thing up anyway. So it should be very easy to fill out and complete. There's an art to this. So the takeaway is just make sure that you have something very clear that shows your contract was vetted under state and federal law, so you can be protected.
Got it. One of the things that we're seeing a lot and a lot of discussion about is on estimates or on contracts covering the rapid price changes and how to deal with how long a bid is good for, or how do you cover things that are due to either rapid price changes or backlogs. There's such a backlog on of jobs, of the supply chain. What are you seeing, and what are you recommending given this unusual situation that we've been having recently?
Right. Well, that's a perfect point. Those would be some of the business operational protections, right? Your contract needs to have as many operational safeguards for you as a contractor as it does legal compliance under state and federal law. Because we're also seeing in these days a sense of entitlement among the customers. We all know this. And a lot of these people are looking for free jobs. They're looking to take advantage of us. And you've got to have these safeguards built in. And a lot of these contracts, as I say, are either have come from industry experts in 1975 who don't know what they're doing, think they do, but they don't. Or we've taken them from other contractors that we worked for, or competitors. And they lack this type of safeguard. One of them certainly we're running into now is this problem with backlogs, as you point out, which we're seeing because of the COVID-related circumstances that we're having. Some of our contractors are running anywhere from 3, 4, 5, 6 to 8 month backlogs on window installs, especially, and some of the other more complicated products. So one of the standard business protections you'd want to have in your contract would be something governing delays or unforeseen circumstances. And I did put a slide together. I can't stand when speakers are reading things off verbatim, but this is just a sample. So this is something that we use in a lot of the contracts for some of our national players. And it just says, and I'll paraphrase, events that are beyond our control. So we're talking about labor strikes, weather, material shortages, financing fallouts, right? Delays by the government in approving inspections or permits, things like that, do not constitute abandonment of the job. And they're not included in any timeframes that we've estimated in the contract. And if something crops up, like unforeseen pricing, or the sales rep has screwed up their measurements, which they do all the time, and we can't do the job, we have 30 days after execution of the contract to give the deposit back and cancel the job. And that's something that comes in handy at least a couple times a year when we find out that we've signed up on a job that is completely ineffective as to cost. The measure tech screwed it up. The sales rep has mispriced it. We didn't catch it at the office, and we've got to get out of the job. Or the job, is loaded with rotten wood, and we're going to have to do a complete re-roof. The customer's giving us problems. That's how we get out of the contract. So in these times of extensive backlogs, having this type of business protection in your contract is absolutely critical. But
what happens if a firm, discovers an issue like that outside the 30 days?
Well, you give it a shot. If you need to get out of the contract, you can still give it a shot, certainly, and point to this. You could always make it a 60-day provision if you needed to. But it's not just a legal issue in our industry, it's setting expectations. So we're having a lot of problems now with these extended backlogs where the customer is becoming increasingly unhappy. And one of our concerns is that as we see inflation really becoming close to out of control, it's not out of control, but if someone doesn't do something, it's getting there. And if that happens, we're concerned that a lot of our contractor clients who are running install backlogs of 6 or 7 months are going to start getting calls next quarter from customers saying, you know what, cancel the job. I just don't want it. It's taking too long, and now I can't buy my G.I. Joe doll for my son for Christmas, and I can't take my family out to Sunday night Chinese food because my gas prices are too high. And there's this domino effect from inflation, and we're concerned that the backlogs are going to start having issues. So the way to address that is not legal so much, but you have to set expectations for the customer. So the best way of handling that is put yourself in the mind of the consumer. Make sure you're touching base with them every week or 3, telling them where you are with the order, apologizing them. Our larger national clients, we're having them send a little box of cookies on jobs that are over $10,000 or $15,000. After 45, 55 days, we'll send a little box of cookies. Thanks for your patience. I know we're all working together in these difficult times. We're looking forward to giving you a great quality install. It's all about setting the expectations. The legal is fine, but in these days, when you're running a 6 or 7 month backlog on an install, the legal is not going to get you there. You need to have that customer comfortable and understanding where you're going with the job.
Yep. No, we definitely hear from the research we run, right, that communication is the top challenge that homeowners feel when they take on a project and hire a contractor. That getting good proactive communication and just knowing that status is often missing, and really is a critical piece to keeping clients happy, especially in these challenging situations when they understand it intellectually, right, but they're personally frustrated. So
absolutely. Yeah. And too many of us just lose that. We're only concerned about converting that lead, closing the sale, and then we'll get to the install when we get to it. And I'm afraid that's going to start causing problems with this backlog situation, but we'll see.
Got it. One of the things that I know we're planning to talk about is the sort of lead paint, which I was surprised to see come up. It feels like it's something from the 70s. Why is lead paint still following us around, and what do contractors need to know?
Right. Again, I'm always hesitant about putting the audience to sleep. Lead paint is the number 4 liability in the industry. It has been for years since the regulations were changed some time back. And if we've got people in the audience that this is not ringing a bell with them, okay, you're assuming the risk, and I get it. We're just going to run through this very, very briefly because it's, we do a 6-hour seminar on this. But understand, one violation, one lead paint violation can have a maximum fine of $37,500. So Hanson's Windows, which we sold about 2 years ago, a lot of folks in the audience may be aware, they got hit with a lead paint violation. And this is just record keeping. We're not talking about people getting poisoned by lead paint chips and anything. I'm not talking about any of that. And the EPA came after them for $113 million. And it took us 5 years to get out of that. So we deal with the lead paint issues at the state and federal level all the time, and it's targeted entirely on the remodeling industry. So running through very, very quickly, hopefully everybody's well versed in this. But if you're doing a job on a house that's from 1977 or earlier, you're supposed to be delivering a lead safe pamphlet that's issued by the EPA. Rhode Island has their own version. And you're supposed to be getting the customer's acknowledgement that they've received this before work began. Now, right there, if you're not using the pamphlet, you can get hit for $37,500 on every job you didn't give the pamphlet. You're supposed to be verifying the age of the house, because if it's from 1977 or before, you're then supposed to be testing for lead paint. There's an exemption under the Toxic Substances Control Act, which is TSCA, where if you're disturbing less than 6 square feet of paint per room or 20 square feet externally, you're going to have that exemption, but you got to be able to prove that. Otherwise, you have to test for lead paint with one of the lead paint test kits. You have to have the results certified. You have to give a copy of that to the customer. And then you actually have to have a certified renovator licensed by the EPA or the state, depending on where you're operating, perform the lead safe work practices, and provide a certified checklist to the customer, do clearance testing, provide that to the customer as well, and they have to be licensed. So just very briefly, if there are a lot of people who are listening, looking at this and they have no idea what I'm talking about, okay, I get it. There's an assumption of risk there if you think you're under the radar screen. But be very careful when you're doing a house that's from 77 or before and you get a customer complaint, because if they go to the wrong attorney or they file the wrong complaint with the wrong agency, they're going to say, prove to us that you did the lead paint testing or prove to us you were exempt. And if you don't have it, boy, it can be a real nightmare.
Good to know. That was very succinct. I don't think you put anyone to sleep with that. That was very helpful.
Fair enough.
Job. All right, so let's transition into class action disasters. And I know we've got a lot of small businesses out there saying, like, is this relevant? Well, what do I need to know?
This is the most relevant of everything, because everything we just discussed, the 1099 issue, the contract issue, lead paint issues, all these top liabilities for 2022, they all can come into the problem of the class action. All right. The 1-800 Sue Your Lawyers love our industry. We have a habit of just screwing things up and opening our kimono to these guys, and they just come after us, large or small. So probably the most important takeaway from our discussion today is to get a class action waiver into your contract. And if that's going to be enforceable, and again, these are just samples and it's very fluid depending on the state, it should be part of an arbitration agreement, because the strongest class action waivers are built into arbitration agreements. I won't put anyone to sleep as to why that's the case. But the class action waiver in arbitration will keep the dispute confidential, private, no jackpot jury awards from juries that hate home improvement contractors. And the example I've got here is just a very sample basic clause that talks about if there's any dispute, you agree you're not going to be a member of a class, and we're going to arbitrate instead of taking this into a class action. And it can literally be a lifesaver. So the takeaway, again, is that while you're making all the wonderful money and you're having such a great time, make sure you take steps to protect yourself to keep the money you've made. And in regard to the class action waiver and the arbitration, that would apply as much to your employees and your independent contractors as it would to your customer contracts. You should have this everywhere if you really want to protect yourself going forward.
Excellent. And thank you for the example. I think that's really helpful. All right, we're going to jump and see if I think we've got a bunch of questions here from folks. So we'll get to a couple of these. So Michael, wants to know, if a contractor wants to have some installers as employees and some as independent contractors, is that a problem? Can you have a mix?
It's a huge problem. You don't want to do it. You can't have Johnny doing your window installs and Sally doing your window installs and arguing that Johnny's an independent contractor but Sally isn't. It's almost impossible to do that. We've done it. I don't like doing it. I wouldn't want to try it again. If you're having a mixed installation base, you're red flagging yourself and you're almost guaranteed to lose a reclassification attack. It's almost a red flag where you're saying, look at me, I'm using independent contractors improperly and I can prove it because I have people doing the exact same job and their employees. So we try to stay away from a mixed base as much as possible. Got it.
And if someone's a kitchen and bath remodeler, they're a small firm, doing a handful of jobs a year. It sounds like it's sort of based on specialty, so they could have a sub for one specialty, but employees that focus on another specialty part of the job, that would be okay, but not two doing windows or not two doing tile, two different specialists, internal and external.
Yes, it's risky, but we have done it. For example, we had a roofer that had some specialized vendors that were doing copper work, which is very unique. And we structured the copper guys as employees, as skilled tradesmen, everybody else is independent contractors. But it's a risky concept to blend your base like that. So you want to be very careful. And that brick wall, those protocols I talked about, there are a lot more than those, and they have to be based on the state in which you're operating.
Got it. All right. Let's see. John says, I understand it's important to take pictures of the job where you're doing lead safe work practices. How long do you have to keep copies of those pictures if you're not uploading them into a software system?
That's an excellent point. I want to be careful. I don't want to tick anyone off too much. I know a lot of the CRM operations that are out there, and some of them we represent are good, and they have this system where you take pictures of the job in progress for lead safe work practice protocols and you put them in there. It's a terrible idea. And it came out of some consultants, I think back in the 80s, and somehow it's become standard in the industry. I have never seen pictures of a job site where lead safe work practices are being done where I can't find something wrong. And all you do by taking pictures is you create bulletproof evidence that you've screwed up the work. That's it.
So you recommend, not
no pictures.
No pictures. Okay.
Yeah. The only time we would ever recommend pictures is if you're out in the countryside in Texas or Virginia or down south and you're doing work on a historic home or an old barn and the place is littered with paint chips already. Then I take pictures to show the before. Other than that, every time we get pictures in a client file of this, you can point out things that are done wrong, and it's better to have no evidence than to have evidence. So to answer your question, I wouldn't be taking pictures at all if we could avoid it. I think it's a very bad idea.
Okay, got it. All right, we got time for one more. Sheila had a contract question. She says, isn't the contract basically a proposal and then the customer accepts it? When does it actually become an enforceable contract?
Well, this was very common from a lot of the quote industry experts back in the 1970s, where the contract at the bottom would say, this is a proposal only. It has to be accepted by the contractor. And that's a terrible format. You want a binding contract when you leave the home. You want an enforceable binding contract when you leave the home. If your contract says anything about a proposal, you need to get rid of that right away. Because what happens in the real world, we don't do that. The customer signs, contract comes back to the office, nobody countersigns it. Or if we do countersign it, we don't then give a copy back to the customer. And so when the poop hits the fan, the government or the 1-800-SUE-YOU lawyer comes in and says, you either never signed it, it was a proposal, or you never returned a signed copy to the customer, so it never became a binding contract. And the entire proposal concept is a defective idea left over from the 1970s. We should stay away from it. Get rid of that on the contract entirely. The contract should be binding and enforceable when the sales rep leaves the home.
Perfect. Well, thank you so much, DS. This was amazing, an amazingly, succinct and extremely valuable and helpful overview of, I think the big gotchas in 2022 for a lot of the building and remodeling firms out there. So really appreciate your insights and your time, and we wish you very happy holidays and New Year.
And to you guys, I hope it didn't scare anyone too bad, but these are the important issues for 2022, guaranteed. So we want to protect ourselves.
Thank you.